I just unmuted us. Chicago, could you please unmute?
Yeah. Jack, can you hear us?
Yes, we can hear you. Sounds great.
I have a text. Oh,
I'm here.
I have a text from Catherine. She's in the building. So there she is. Good. All right. Let her get down and she's not here today. She's unable. So she's traveling or something.
So who do we have here? Which cases are covered by the
He is on 103,
Uh-huh,
554.
okay.
Then the withdrawal, 10
I'm sorry, which one for withdrawal?
102.
Okay.
Are we ready? Okay, everybody's here and I will call the meeting of the State Board of Elections for Tuesday, December 9th in order. It is 9 a.m. and if you would all stand, we'd do the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America,
And
to
to
the
the
republic
republic
for which it stands, one nation, under God, indivisible, with liberty and justice for all.
That's it.
Okay.
All right, Amy, roll call, please.
Ms. Bellercroft? Ms. Craig?
Present.
Ms. Genovese?
Here.
Ms. McQuarrie?
Here.
Mr. Brett?
Here.
Ms. Watson?
Here.
Vice Chair Turbin?
Here.
Chair Donahue?
Here. All right. We will now we want to recess the State Board of Elections and reconvene as the State Officers Electoral Board. Amy, do I need a motion to that? A second? It's been moved and seconded. Amy?
Ms. Bellercroft?
Yes.
Ms. Craig?
Present.
Ms. Genovese? Yes. Ms. McQuarrie?
Here.
Mr. Brett?
Yes, or here.
Ms. Watson?
So yes.
Yes.
Vice Chair Turbin?
Yeah.
Chair Donahue? Motion
Yes.
passes.
Now we need, as the State Board of Electoral Board, I need a roll call for attendance within that.
Ms. Bellercroft? Ms. Craig?
Yes.
Ms. Genovese?
Here.
Ms. McQuarrie?
Here.
Mr. Brett?
Here.
Ms. Watson?
Here.
Vice Chair Turbin?
Here.
Chair Donahue?
Here. We ought to have a motion to decrease our roll calls. All right, I need a motion to approve the minutes of our November 18th State Board of Electoral Board.
So move.
Second.
Amy?
Ms.
Roll call.
Bellercroft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yeah.
Chair Donahue?
Yes.
Motion passes.
All right. Marnie, we now will go to consideration of objections to established party candidate nominating petitions for the March 17th, 2026 general primary election. We'll start with 2A, Bowlby and Trubugi.
Thank you. If I could read a brief introduction, just so people know how to collect their orders, that would be lovely.
Yes. Sorry about that.
No problem. So I'd like to thank everyone for being here today. I'm Marnie Malowitz, General Counsel to the board. Today, the board will be hearing objections to the nomination papers of candidates seeking to appear on the ballot for the general primary election on March 17th, 2026 as established party candidates. For each case called, I will read a summary of the objection, a recommendation of the hearing officer, and my recommendation on the disposition of the matter. I will keep it brief and simply summarize. Objectors will then have no more than 3 minutes each to make oral arguments to the board, followed by candidate, who will also have no more than 3 minutes. Staff in Springfield will be using a stopwatch to ensure arguments stay within the time limit. The board may grant you more time for argument if you wish, but under Rule 11, they have the ultimate authority to decide what oral arguments may proceed. The board has 27 electoral board cases to hear today, and the parties have already been given an opportunity to present evidence and argument to their hearing officer. The board has been given copies of the objections, dispositive motions and briefs, hearing officers' recommendations, and any exceptions to hearing officer recommendations to consider. So there's no need to reiterate arguments that you've already advanced before your hearing officer. Please also remember that no new evidence is to be presented here today. This is an opportunity to make legal arguments and explain your position to the board. Once the board has voted on your case, it will take several minutes for board staff to prepare your board order. You can pick up a copy of your board order up here in Chicago from our legal counsel to Sean Sarku, who is in the back of the room, if you don't mind raising your hands. And in Springfield, you can pick up your board order from our Deputy General Counsel, Jordan Andrew. I can't see you, but hopefully you can raise your hand.
Here.
Thank you, in the Springfield office. So once you have your order, if you have no other matters before the board, you're free to leave if you prefer. Thank you to the board staff and especially the legal staff for all the effort you've put into electoral board matters so far. We've got a long way to go, but this is definitely a good start. And with that, I will call the first case. This is agenda item 2A, Bowlby versus Tabruge, case 25 SOEB GP 101. I'm not seeing anybody present in Chicago. Is anyone present in Springfield?
No, ma'am.
Okay, well, because it's the beginning of the meeting, we could consider skipping it, or we could consider dismissing the case for want of prosecution.
I would entertain a motion to dismiss for want of prosecution.
So moved.
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turvin.
Here.
Chair Donahue,
Yes.
motion passes.
All right. Marnie?
Next case, agenda item 2B, Betts versus Johnson, 25 SOEB GP 103. I have Kevin Morphew on behalf of objector. Is Mr. Morphew present?
He
Oh,
is present in Springfield.
Yes.
excellent, thank you. And is the candidate present? Hallie Johnson?
Oh.
Okay, I'm going to read my recommendation and then Mr. Morphew will have 3 minutes to address the board. So this is an insufficient signatures case. Objector Betts, represented by attorneys Kevin Morphew and Mike Casper, filed an objection to the nomination papers of candidate Johnson, Democratic Party candidate for representative in the 112th representative district. A staff signature count showed candidate had gathered 259 signatures, which is 241 fewer than the 500 required for ballot access under section 8-8 of the election code. For this reason, the hearing officer recommends, and I agree, that the objection should be sustained, and candidate Johnson's name should not be certified on the March general primary ballot as a Democratic Party candidate for representative for the 112th representative district.
Mr. Morphew?
We agree with the hearing officer and the general counsel's recommendations and ask that they be adopted.
Do I have a motion?
Make a motion to accept the recommendation of the general counsel and not place Hallie Johnson on the ballot for the March 17th, 2026 primary.
Second. It's been moved and seconded. Amy?
Ms. Bellicroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese. Yes. Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
yes,
Vice Chair Turbin,
Yeah.
Chair Donahue,
Yes.
motion passes.
Thank you.
All right, Marnie.
Agenda item 2C, Malo versus Lauren, 25 SOEB GP 104. The objector never appeared in this case and does not appear to be present. On behalf of the candidate, we have attorney Luis Atzaves. Normally in these cases, we give the candidate the opportunity to decide whether they'd like me to read the recommendation on the merits or if they are satisfied with the dismissal for want of prosecution.
Is-
And Mr. Atzaves, if you could stand under that green light that's difficult to see, that's the microphone.
Here,
Yes, thank you. So hopefully they'll be able to hear you. In Springfield.
thank you. Good morning. We would be satisfied with a motion to dismiss for want of prosecution under the circumstances, but we also stand on our motion to dismiss.
Thank you.
I move to dismiss for want of prosecution.
Second.
It has been moved and seconded. Amy?
Ms. Bellicroft,
yes,
Ms. Craig.
Yes.
Ms. Genovese. Yes. Ms. McCory,
Yes.
Mr. Grant,
Yes.
Ms. Watson,
yes,
Vice Chair Turbin.
Yes.
Chair Donahue,
Yes.
motion passes.
Amy, Marnie.
Thank you. Next case, 2D, Chapman versus Krishnamurthy, 25 SOEB GP 500. We have the objector Chapman here in Chicago, as well as candidate Krishnamurthy here by his attorney, Michael Dorff. So objector Chapman filed an objection to the nomination papers of candidate Krishnamurthy, who's a Democratic Party candidate for U.S. Senator. The objection petition claims candidate is not a U.S. citizen and as a result is unqualified to hold the office of U.S. Senator. Candidate filed a candidate's motion to strike and dismiss objector's petition, attaching the candidate's certificate of citizenship issued by the United States Department of Justice, as well as his United States passport. The objector filed motions detailed both in your summary sheets and in motions in pages 41 through 448 of your packets. Objector's motion for summary judgment argues candidate is not a citizen, and objector's motion for default argues for various relief, including criminal referrals of the candidate. The hearing officer recommends, and I agree, that candidate's motion to strike and dismiss objector's petition should be granted because the proof provided by candidate, primary evidence establishing his citizenship, and candidate Krishnamurthy is qualified to hold the office of United States Senator. I further agree with the hearing officer's recommendations to deny objector's motion for summary judgment because it fails to offer evidence the candidate is not a citizen, and objector's motion for default I recommend should be denied because candidate appeared in this proceeding through his counsel, Mr. Dorff, as permitted by our rules. If all of the objector's motions are denied, all relief he seeks will be denied. The objection, therefore, should be overruled, and the name of candidate Krishnamurthy should appear on the March 2026 general primary ballot as a Democratic Party candidate for the office of U.S. Senator. Now, over the weekend, on December 7th, objector Chapman's opposition and objections to hearing officers' fatally defective, erroneous, corrupt, and compromised findings and recommendations was filed, and each board member has been provided a copy of this opposition. In it, objector argues the hearing officer's recommendation is invalid, mentions impermissible burden shifting upon the civilian objector, and again argues that criminal referrals are appropriate in this matter. Yesterday, an amended version of candidate's opposition was filed as well. These filings do not alter my recommendation to overrule this objection. And with that, Mr. Dorff.
But you mentioned Mr. Chapman's here. I don't see him standing.
Yes,
anywhere. Thank you for standing up, sir.
Thank you.
Mr. Dorff.
We concur with the recommendation of the general counsel. That's that the objection be overruled.
Mr. Chapman.
The objections that were filed under oath and with a affidavit, sworn affidavit is notarized must be taken as evidence. The hearing officer and counsel for the Illinois State Board of Elections failed to do that. And if it's taken as evidence, the board, the State Board of Election, will know that it has no jurisdiction whatsoever to decide citizenship issues. It has no jurisdictions whatsoever to decide passport issues or validity. It has no jurisdiction whatsoever. Subject matter jurisdiction is with the INA, the Immigration Naturalization Act. All these other hearings are within the jurisdiction of the Illinois State Board of Election because they contest the certificates, the petitions. I am contesting citizenship, and anything that has to do with citizenship is a federal issue and not a state issue. And for the hearing officer to say in his findings and in his recommendations that Mr. Christy Morty, who was sworn as a national of New Delhi, India, with evidence in accordance to the rules of procedure before the Illinois State Board of Election, cannot be classified by the council or the hearing officer as a citizen of the United States of America. The hearing officer said that there was a valid passport dated sometime in 2022. Well, the reason that valid passport was dated 2022 is because 2020, I filed a petition with the House of Representatives to have Mr. Krishnamurti removed from the House of Representatives because of his alien status. That is part of my certificate of objections as sworn on the oath.
And sir, you're past your 3 minutes. Thank you.
I wonder if I may have the remainder of my 3 minutes.
Madam Chair, is that okay?
Continue, Mr. Dorff. Yes.
Thank you. First, I would just like to say that the objector cannot both argue that the State Board of Elections is not a jurisdiction, while at the same time, this whole matter began because the objector voluntarily filed an objection, therefore subjecting himself to the jurisdiction of the State Board of Elections. Secondly, and I wasn't really planning on making any remarks, but since the objector has continuously attacked me both personally and professionally, I would like, not as a matter of new evidence, but simply as a matter of persuasion, to read a statement from the Appellate Court of Illinois, 2nd District, which was issued 3 weeks ago in In Re Estate of Ingram, 2025 Ill App 2nd, 240659-U, which I am citing under Illinois Supreme Court Rule 23E, purely for persuasive purposes. Quote, as we have discussed, Chapman's appeal is utterly without merit. His brief consists largely of baseless accusations of a vast criminal conspiracy against him by inter alia several judges and lawyers, including opposing counsel and the trial judge in the underlying case herein. The few cognizable arguments to be gleaned from Chapman's brief fail to address the basis for the trial court's judgment and consist primarily of accusing the administrator of being an illegal immigrant without any substantiation. Further, we find that Chapman's appeal was not taken in good faith. Chapman, a self-described juristician, proudly claims that the federal courts have described him as a prolific pro se litigator. That much appears to be true, though it is not the compliment Chapman takes it as. The United States District Court for the Northern District of Illinois has entered a regulatory injunction to limit Mr. Chapman's ability to file repetitive and frivolous suits. In issuing the rule to show cause, which ultimately led to this sanction, the court described Chapman's litigation history as follows. Quote, when viewed in its entirety, the record reveals a disturbing pattern of Chapman transforming his own misdeeds into lawsuits against anyone, judges, creditors, local politicians involved in exposing his transgressions or challenging him in any way. Viewing the facts of this case in light of Chapman's litigation history, there is no reason to believe Chapman was acting in good faith when he filed the instant appeal. Accordingly, we find that sanctions are appropriate under Rule 375B. And I will suggest that if this case goes to the circuit court or the appellate court, this case will be used for sanctions against the objector.
May I address his issues?
It's up to the
Um,
chair.
You've had your comments, sir, and is there discussion by the board? Do I have a motion?
I make a motion, we follow the hearing officer's recommendation that the board strike and dismiss the objection in its entirety and certify the candidate's name for the March 17th, 2026 general primary ballot as a Democratic candidate for the office of the United States Senate.
Thank you.
Second.
It's been moved and seconded. Amy, roll call?
May I add two things to that recommendation because there are outstanding motions?
Yes, Marnie.
So Member Turbin did mention granting the motion to just strike. We also need to deny objector's motion for summary judgment and motion for default.
So moved.
Second.
It's been moved and seconded. Amy, roll call.
Ms. Bellicroft,
yes,
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
yes,
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you. Marnie?
Thank you. The next case is agenda item 2E, Gordon versus Holt, 25 SOEB GP 501. Our sign-in sheet is showing that neither objector nor candidate is present. Oh, sir.
I'm present. I'm Mr. Holt.
Oh, okay, excellent. Thank you, Mr. Holt. All right, so candidate Holt is present, but nobody is present on behalf of objector Gordon. So
None
in-
down here.
Okay, in that case, Mr. Gordon, again, I normally give the candidate the opportunity. Would you rather this case be dismissed for one of prosecution, or would you rather have this case ruled on the merits? In which case, the objection would be sustained.
I would ask for it to be dismissed on warrant of prosecution. So moved.
Second.
Amy, roll call?
Ms. Bellicroft?
yes,
Ms. Craig?
Yes.
Ms. Genovese? Yes. Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
yes,
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
I should let you know, Amy, that I can really barely hear
Oh,
you.
I'm so sorry. Let me grab.
Oh,
That is our error. Sorry.
yeah, we had to do the mic.
Okay, is that better?
Yes, it is, thank you.
May I proceed?
Absolutely. Sorry, Marnie, go ahead.
No problem. Thank you, Madam Chair. Next is agenda item 2F, Smith versus UFO Decay, 25 SOAB GP 510. I see counsel present on both sides, if they can both stand under the green light or close to it. I will read my recommendation and then each side will have 3 minutes to address the board. This is maybe our most complicated case of the day, if not in the top 3, so bear with us all. This case presents a purely legal question. Objector Smith, represented by attorney Jeffrey Meyer, filed an objection to the nomination papers of candidate UFO Decay, who's represented by attorney Atsaves. The objection alleges candidate's nomination papers are invalid because candidate's statement of economic interests filing receipt is from the Lake County clerk rather than the Illinois Secretary of State. the objector filed a motion for summary judgment, arguing that filing a statement of economic interest receipt from the incorrect entity does not constitute substantial compliance with the election code, and that the candidate should be removed from the ballot, citing to Ferrand, Ferrand versus City of Chicago Board of Election Commissioners, 2014, Ill App First, 140225. Candidate filed a motion to dismiss verified objector's petition, making a number of arguments, including citing Rotman, Rottman, versus Illinois State Officers Electoral Board, 2018, Ill App First, 180234, for the proposition that one need only file a statement of economic interest with an appropriate government unit under section 7-12(8) of the election code. Also arguing the legislature did not intend for this to mean filing with an office other than Secretary of State did not satisfy the election code. Here, the hearing officer recommends granting the objector's motion for summary judgment and denying candidate's motion to dismiss because sections 7-12(8) and 8-8 of the election code, when read together, provide that a candidate for the General Assembly must file a statement of economic interest with the Secretary of State before the end of the filing period and file a filing receipt for that statement of economic interest with the State Board of Elections. The hearing officer disagrees with candidate's contention that she substantially complied with the law by filing her Lake County filing receipt with the board. Candidate's reliance on Rotman, Rottman, is misplaced because the candidate in that case filed for 2 state offices, whereas candidate in this case filed for 1 local position and 1 state position. The objector's argument, relying on Ferrand, Ferrand, is compelling, as in that case, the court rejected the candidate's argument that while running for a state office, she had substantially complied with sections 7-12(8) and 8-8 of the election code by filing with the State Board of Elections a statement of economic interest filing receipt issued by the Cook County Clerk. As the facts of Ferrand match the facts in this case in all relevant respects, the hearing officer recommends, and I agree, granting objector's motion for summary judgment, denying candidate's motion to dismiss, finding the nomination papers invalid, sustaining the objection, and not certifying candidate for the March 17, 2026 general primary ballots. Now, on December 5th, a response to hearing officer's final recommendation by respondent candidate Tosi Ufudike was filed, and each board member has been provided a copy of that response. Among other arguments, that document alleges that the hearing officer, quote, glosses over the interpretations of the Illinois Constitution, Article 13, Section 2, concerning units of government, the statement of economic interest question to be answered by candidates for office, and where such documents are required to be filed, unquote. Now, looking back to candidate's motion to dismiss, which appears at pages 477 to 478 of your packets, there is a reference to implementing statement of economic interest following the passage of the 1970 Constitution, followed by a discussion of the interpretation of the phrase governmental unit in the Rotman case and in section 7-12(8) of the election code. But the phrase governmental unit does not appear in the Illinois Constitution. So if the candidate was making a constitutional argument, it's unclear what that argument was. My recommendation remains the same after reviewing candidate's response. And before we turn to the parties, I would ask that I be given a moment to assist in compiling a objection for this matter because it's a bit complicated.
Definitely, Marnie. So you want your candidate, you want the Mr.
objector.
Meyer? Okay,
Yes.
Mr. Meyer?
Oh, and if people could spell their names, I apologize. I haven't done that so far. But if Mr. Meyer and Mr. Altaves could do that before they speak, that would be lovely, and everyone else after.
Sure. Jeffrey A. Meyer, Meyer, on behalf of the objector. we can agree with the recommendation of the hearing officer and the general counsel. The facts here are not disputed. They're admitted facts that the candidate filed a statement of economic interest with Lake County, and then with her nominating papers filed a receipt for having filed that statement of economic interest with Lake County. At no time prior to expiration of the filing period on November 3rd did the candidate file a statement of economic interest with the Illinois Secretary of State's Index Department or any other department with the Secretary of State's office. And at no time did the candidate file a receipt for filing a statement of economic interest with the Secretary of State with the State Board of Elections. Those facts are undisputed. So it's solely a question of law. The Ferrand case, Ferrand, is squarely in point and is binding authority upon this board. The Rotman decision, Rottman, is distinguishable. The principal distinguishing fact in the Rotman case is that there, just like here, the candidate had filed for to run for a state legislative office and had filed their statement of economic interest with the county office. They had filed with the Cook County clerk, just as the candidate in this case filed with the Lake County clerk. Pardon me, that's in the Ferrand case. I apologize. In Rotman, what had happened is that the candidate was running for attorney general and was an incumbent state legislator. That candidate in Rotman had filed their statement of economic interest with the Secretary of State's office. That was a state office. The court found that that was the same governmental unit because it was both the state office, attorney general, and state legislator. And so they found that the receipt was sufficient in that case, even though they were running for a different office. They were running for a different office at the same unit of government. In Ferrand, just as here, you have a candidate who has filed with the county and is seeking office with the state. Those are two different governmental units. That's the distinguishing fact in Ferrand. The only thing that's changed since the Ferrand decision is that the form is now uniform. So the economic interest form used to have some differences between state and local office. Now they don't. But that is not the fact that the Ferrand court relied on. The Ferrand court relied on where did the candidate file, not what the substance was. This board is not concerned with the substance. They're concerned with the location of filing. So the Ferrand decision is still good law. It's binding precedent, should be followed by this board. For those reasons, the candidate's motion to strike and dismiss should be denied. The objection should be sustained, and the candidate's name should not appear on the ballot. Thank you.
Mr. Ostavies, state your name and spell it, please, for the recorder.
Yes, my name is Louis Atsavis. The first name is spelled Louis, and I'm finding out I need to do that more and more these days. Last name is Atsaves. I represent the candidate in this matter. I think the hearing officer was beginning to stretch some of his arguments in support of dismissing the candidate's case in this matter. And in particular, he comes up with a hypothetical saying that because the document was filed with Lake County Clerk's office, but it appears on the receipt that was filed with the State Board of Elections as having been filed with the Lake County Clerk's office, that somehow this would make it more difficult for people to find the documents and to begin an investigation of the candidate. Well, that's clearly not the case here. Not only was it disclosed, but in one of our responses, you can see in the exhibits where we showed each individual statement of exceptions dating back over 5 or 6 years. Questions are the same, the answers are the same. So where are we going with this? The Rotman case showed a clear analysis of the Illinois Constitution as adopted in 1970 when I was a sophomore in high school. And we continue on with attempting to interpret it, but they carved out an exception there. They didn't file something with exactitude as we often face with cases of this nature here. And we are looking at a situation here where the Rotman case is signaling and showing us the path forward on how to handle these type of cases in the future. For that reason, I believe the Rotman case still applies. It's still good law, obviously. It's never been overturned. It's never been overruled. And it stands there in stark contrast to some of the older cases, including the case that the hearing officer and Mr. Meyer relies upon. For that reason, we believe that the hearing officer's recommendation should be overturned and the candidate should be placed on the ballot for this particular election as a candidate for the office that she seeks. Thank you.
Thank you. Marnie, would you like to state the motion and then we'll see if we have someone to accept that.
Sure. So I would suggest a motion to grant objector's motion for summary judgment, deny the candidate's motion to dismiss, sustain the objection, and not certify the candidate to the ballot.
Madam Chair,
Is there-
discussion, please.
Pardon?
Discussion, please.
Yes, I was just going to say that, Jack.
Perfect.
Is there discussion?
Thank you very much, Madam Chair. If I may, I believe that, well, as I think members of this board know, I have long had concerns about the receipt requirement. I know it's statutory, but it frustrates me intensely that we would deny ballot access to someone merely because they failed to, that they, in some instances, they filed a statement of economic interest, but they didn't file a receipt. And I know that it does exist, the concept of substantial compliance, and I may be an outlier, but I think that our overarching goal of ballot access and substantial compliance would in this instance militate in favor of allowing this candidate's name to appear on the ballot. She completed the statement of economic interest, subjected herself to the perjury penalties for misstating what her economic interests were. She filed it with a governmental entity. It was the wrong governmental entity, but I believe that we can take notice of that as the State Board of Elections. And so in this instance, I would be persuaded that our rule should always favor ballot access, and I would ask that she be placed on the ballot.
Thank you, Jack. Is there further discussion? Is there a motion?
And again, the recommended motion is to grant objector's motion for summary judgment, deny candidate's motion to dismiss, sustain the objection, and not certify the candidate to the ballot.
Do I have a motion?
Madam Chair, I make a motion that we back the hearing officer's recommendation of granting the objector's motion for summary judgment, denying the candidate's motion to dismiss, finding the nomination papers invalid, and sustaining the objection and not certifying the candidate for the March 17th general primary ballot.
Do I have a second? Been moved and seconded. Amy, roll call, please.
Ms. Ballarcroft,
Yes.
Ms. Cray,
Yes.
Mr. Nevesi.
Yes.
Ms. McCrory,
Yes.
Mr. Frett,
No.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you. And I was unable to hear who seconded the motion.
It was Ms. Genovese.
Genovese.
Wonderful. Thank you. Thank you.
Thank you.
Take care.
Our
All
next-
right, Barney, next up.
Thank you. Our next case, Lai versus Parker, 25 SOEB GP 516. Objector, Lai is represented by attorney Ross Seckler, who I do not see in Chicago and has not checked in Springfield. Springfield, can you confirm?
No one here.
Excellent. The candidate is represented by attorney John Fogarty, Fogarty. Mr. Fogarty, under these circumstances, we would ask whether you prefer that the case be dismissed for want of prosecution, or you would rather I dive into the records exam.
But on the merit.
Okay. All right, so I will read my full recommendation. So objector Lai filed an objection to the nomination papers of candidate Parker, who is a Republican Party candidate for representative in the 3rd Representative District. Objectors alleged circulator deficiencies, a pattern of fraud, and individual signature line objections. Candidate filed a motion to strike, arguing portions of the objection petition alleging circulator and notary deficiencies were legally inadequate. The objector objected to 937 signature lines of candidates' 1,215 filed signatures. Following the conduct of the records exam, 524 objections were sustained, 413 were overruled, and candidate was found to have 687 valid signatures, which is 187 more than the statutory minimum of 500 signatures. The objector chose to rest on the results of the records examination and not pursue the other claims in the petition. Here, I agree with the hearing officer's recommendation to deny candidate's motion to strike because it was rendered moot when objector chose not to further pursue notarial and pattern of fraud claims. The hearing officer further recommends, and I agree, finding that candidate had 687 valid signatures, more than the 500 required by section 8-8 of the election code, that the objection should be overruled, and candidate Lai's name should appear on the March general primary ballot as a Republican Party candidate for the office of representative in the 33rd representative district.
Is there discussion?
Oh, Mr.
No, sorry, Mr. Fogarty, I apologize.
No apology necessary. Please let us accept the recommendation of the hearing officer and the general counsel.
Excellent. So we would accept the recommendation of the hearing officer and general counsel, deny the motion to strike, overrule the objection, and place candidate Lai's name on the ballot.
So moved. It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig?
Yes.
Ms. Genovese?
Yes.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yeah.
Chair Donahue?
Yes.
Motion passes.
Marnie?
Thank you.
Thank you. Next case, 2H Zimney versus Delgado, 25 SOEB GP 517. We have counsel present. Candidate Delgado, who is a Democratic candidate for United States Senate, waived service in this matter and was served with this objection via email, but he never appeared in this proceeding, including today. The objector's petition alleges candidate filed insufficient signatures, that the address on the statement of candidacy is not a residence address, and that the address on the petition sheet's headers is a different address than that one in the statement of candidacy, causing reason for voter confusion. I'm sorry, Mr. Dorff, I failed to introduce Michael Dorff on behalf of the objector. So in this case, no motions were filed. The hearing officer recommends, and I agree, finding that the candidate filed 1,719 valid signatures, which is 3,281 less than the statutory minimum of 5,000 signatures required by section 7-10A of the election code. In light of the signature deficiency, it is unnecessary to reach the other issues in the objection petition. The objection should be sustained, and candidate Delgado's name should not appear on the March general primary ballot as a Democratic Party candidate for the office of United States Senator for the state of Illinois.
Thank you, Marnie. Mr. Dorff?
Thank you, Madam Chair. We concur with the recommendation of the hearing officer and the general counsel.
Thank you. Do we have a motion? Second. Amy, roll call, please.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yeah.
Ms. Genovese?
Yeah.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yeah.
Chair Donahue?
Yes.
Motion passes.
Marnie?
Thank you. The next case is 2I Miller versus Brown, 25 SOEB GP 522. There's counsel on both sides, Robert Winden for objector and Kyra Kolodakis on behalf of the candidate. Now, I see that neither one is present. Is either present in Springfield or anyone on behalf of objector or candidate?
No one here.
Okay, well, I can let you know that based on records exam results, the recommendation on the merits would be to remove the candidate from the ballot. However, the objector is not here. So the other option is to dismiss the case for want of prosecution. If the board wants to proceed on the merits, please let me know, because then I will read my full recommendation.
Make a motion to dismiss for want of prosecution.
Second.
Second. Been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft?
Yes.
Ms. Craig?
Yeah.
Ms. Genovese?
Yeah.
Ms. McCrory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Next, Marnie?
Thank you. The next is 2J, Fiedler or Fiedler and Smith versus Vajic, VAJIC, It's 25 SOEB GP 524. I see someone is present on behalf of objectors. Hello, sir. Excellent. Thank you, sir. Fiedler. If you could stand near that green light, so that way the microphone can catch what you have to say. First, I will read my recommendation and then you'll have an opportunity to address the board. This is an insufficient signature case. Objectors Fiedler and Smith, appearing pro se, filed an objection to the nomination papers of candidate Vajic, a Republican Party candidate for the office of representative in the 3rd Congressional District. A staff signature count shows candidate filed 194 signatures, which is 251 fewer than the statutory minimum of 445 signatures. Candidate Vajic never filed an appearance in this proceeding, though she did contact the hearing officer about her case without copying the objectors. Her agent spoke to board staff as well, and she also sent an ex parte email to the hearing officer, so she is aware of the proceeding. USPS records show 2 attempts to formally serve the candidate via certified mail, but those were rejected because an authorized recipient was not at home, and 2 notices were left by the USPS. However, the certified mail was never picked up. Here, the hearing officer recommends finding the candidate had sufficient notice of this proceeding such that the board does have jurisdiction. The hearing officer further recommends that the objection be sustained as the candidate submitted fewer than the statutory minimum of 445 signatures required by section 7-10B of the election code, and the name of Spomenka Vajic should not be certified to the ballot as a Republican candidate for representative in the 3rd Congressional District.
Thank you, Marnie. Mr. Fiedler, do you have any comments?
Just that we concur with the hearing officer's recommendation.
Good. Thank you. Do I have a motion?
Make a motion to accept the recommendation of the general counsel and hearing officer and not certify the candidate for the March 17th, 2026 general primary.
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese.
Yes.
Ms. McCrory,
Yes.
Mr. Frett,
Abstain.
Ms. Watson,
Yes.
Vice Chair Turvin.
Good.
Chair Donahue,
Yes.
motion passes.
Thank you.
Next, Marnie, please.
2K Lanigan versus Scala, 25 FOEB GP 525. I have appearances on file for objectors by Heather Wire-Vaught, Adam Vaught, and David Adeleye. Am I saying that correctly, sir?
Adeleye, we'll get it right.
All right, I'll work on it. You'll train me. Adeleye. And on behalf of the candidate, we have Mr. Fogarty. This
All right.
is a records examination case. Objector Lanigan, represented by attorneys Heather Wire-Vaught, Adam Vaught, and David Adeleye, filed an objection to the nomination papers of candidate Scala, Republican Party candidate for senator in the 14th Legislative District. Objector is represented by attorney Fogarty. Objector objected to 1,238 lines of candidates' 2,132 filed signatures. Following the conduct of a records exam, 1,080 objections were sustained, 203 objections were overruled, and candidate was found to have 1,052 valid signatures, which is 52 more than the statutory minimum of 1,000 signatures. The hearing officer recommends, and I agree, adopting the results of the records examination, finding that candidate has 1,052 valid signatures, which is more than the 1,000 minimum required by section 8-8 of the election code, that the objection should be overruled, and candidate Scala's name should appear on the March general primary ballot as a Republican Party candidate for the office of senator in the 14th Legislative District.
No objections.
Thank you, Marnie. So who do we have? Does anyone up there wants to speak?
I
Okay.
believe that both candidate and objectors counsel are shaking their head no.
Okay. Do I have a motion? I make a motion to. Marty, help me here, that they have the required number of signatures and they should be on the ballot.
Correct, and that the objection is overruled.
There you go. I make that motion. Is there a second?
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yeah.
Chair Donahue,
Yes.
motion passes.
Barney?
Agenda item 2L, Johnson versus Henderson. 25 SOEB GP 528. On behalf of Objector Johnson, represented by attorneys Heather Wire-Vaught, Adam Vaught, and David Adelia. No? Yeah, okay. Excellent.
We're gonna keep working on it.
And we're gonna keep working on it. You'll train me. Filed an objection to the nomination papers, and I apologize. An objection to the nomination papers of candidate Henderson, Republican Party candidate for senator in the 15th Legislative District, and who is represented by attorney John Fogarty. Objector objected to 834 lines of candidates' 1,302 filed signatures. Following the conduct of a records exam, 711 objections were sustained. 123 were overruled, and candidate was found to have 591 valid signatures, which is 409 fewer than the statutory minimum of 1,000 signatures. The hearing officer recommends, and I agree, adopting the results of the records examination, finding that candidate has 591 valid signatures, which is fewer than the 1,000 minimum required by section 8-8 of the election code, and that the objection should be sustained. And candidate Henderson's name should not be certified to the March general primary ballot as a Republican Party candidate for the office of senator in the 15th legislative district.
Thank you, Marnie. Let me see. The objector, the attorney for the objector.
Is it Adelia?
Adelia.
Delia, sorry about that.
Adelia, all right, now I got it. Adelia. Sir, would you like to make a comment?
No comments here. Council have confirmed outside the chamber and, we're good.
Mr. Adelia is speaking for me.
Oh, all right. Okay, I make a motion to sustain the objection and not place the candidate's name on the ballot. Second? Anywhere? Do I have a second? Second. It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese, Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yeah.
Chair Donahue,
Yes.
motion passes.
Marnie.
Thank you. The next case, 2M Rice versus Abu Ghazalov, 25 SOEB GP 535. Objector Rice appeared pro se, and the candidate appeared by Scott Erdman, attorney. I do not see either side present in Chicago. Is anyone present in Springfield?
No.
Okay, in that case, the board has the option to dismiss for want of prosecution, or I can read my recommendation and the board can decide on the merits.
Continue, Marnie.
Okay. Objector Rice filed an objection to the nomination papers of candidate Abu Ghazala, who is represented by attorney Scott Erdman. The candidate seeks the office of representative in Congress for the 9th Congressional District. The entirety of the objection reads, I, Maxwell Rice, hereby object to Kat Abu Ghazala's candidacy on the ground of the signers not registered to vote at their address, unquote. Respondent candidate's motion to strike and dismiss objector's petition argues this objection fails to meet the requirements for an objection under section 10-8 of the election code. No response to the motion to strike was filed. The hearing officer recommends, and I agree, that respondent candidate's motion to strike and dismiss objector's petition should be granted because the objection petition fails to meet the requirements contained in section 10-8 of the election code. That section requires an objector's residence address, the nature of the objections, the interest of the objector, and the relief sought. Accordingly, the objection is stricken and the candidate's name should appear on the March 17th, 2026 general primary ballot as a Democratic candidate for the office of Representative in Congress for the 9th Congressional District.
Thank you, Marnie. Is there anyone there to speak?
There is no one present in Chicago.
There's no one here. Do I have a motion? Do you have a suggestion, Marnie?
Sure, I would suggest accepting the recommendation of the hearing officer and the general counsel, granting the motion to strike and dismiss objector's petition, finding that the objection is stricken and that the candidate's name should appear on the ballot.
So moved.
Do I have a second?
Second.
Been moved and seconded. Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion passes.
All right, Marnie. Halfway home.
Thank you. Agenda item 2N, Rice versus Mendrick, 25 SOEB GP 536. Same objector appeared pro se, but does not appear to be present. And on behalf of Mr. Mendrick, Kent Mercado does not appear to be present either, although is Mr. Mercado present anywhere?
Nope, none here, not here.
Okay. So the objection, options are to dismiss for want of prosecution or to proceed on the merits, in which case the candidate would not be on the ballot.
Is there discussion? Do I have a motion?
Can I just say whoever's phone keeps going off, can you please silence it? Thank you. Sorry for the interruption.
No problem, Ms. McCrory. Do I have a motion?
I would make a motion.
Oh, I'm sorry, I misspoke. The objection would be the candidate will be on the ballot. I very much apologize for that. So the two options are dismissal for want of prosecution or striking the objection.
I make a
All
motion.
right, so the motion, go ahead.
Make a motion to
Kathleen.
accept the recommendation of general counsel and strike the motion.
Strike the objection.
Or strike the objection, excuse me.
Second.
It's been moved and seconded. We're all straight on it?
Yeah.
Okay. Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett. Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion
Marnie.
passes.
Excellent. Next case, agenda item 2O, Mebane and Schaefer versus Donos. The objectors are represented by Andrew Finko, who does not appear to be present in Chicago. Can you confirm that Mr. Finko is not present in Springfield?
Yes.
And that the candidate per se is not present in Chicago?
Not here either.
Okay, excellent. So the options here would be first to dismiss for want of prosecution, or alternatively to rule on the merits and overrule the objection.
Do I have a discussion? Do I have a motion?
Marnie, may I ask one question about this?
Of course.
Ms. Craig?
If we don't do one of prosecution and we do it on the merits, it said the hearing officer recommended waiting for another hearing to be held for 5:32.
So
If we,
I'm sorry, go ahead.
if we do one of prosecution, we don't have to worry about that, correct?
That's correct, but we could also just overrule this objection, but not make a recommendation on whether or not the candidate be certified to the ballot. So it's equally easy to dismiss for want of prosecution and to rule on the merits by overruling the objection.
Okay, I'll make a motion for one of prosecution.
Do I have a second?
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Dollar Croft,
Present.
Ms. Craig,
Yes.
Mr. Nevezi,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Present.
Vice Chair Turbin.
Yeah.
Chair Donahue,
Yes.
motion passes.
All right. Marnie.
Agenda item 2P, Cabello and Wright versus Katover, 25 SOEB GP 540. On behalf of objectors, we have Mr. Fogarty, who filed an objection to the nominating petitions of George Donos, a Republican candidate for the office of Representative in Congress for the 16th Congressional District, confirming Mr. Donos is not present in Chicago.
Mr. Kitover.
Oh, Mr. Katover, I'm so sorry. Thank you, thank you. My script it failed me. Excellent, thank you. So the objection petition alleges individual signature line objections and a pattern of fraud. The objector filed a miscellaneous motion requesting various forms of relief, but it was already denied by the hearing officer as untimely. Objector objected to 1,468 lines of candidates, 1,652 filed signatures. Following the conduct of a records exam, 1,386 objections were sustained, 82 were overruled, and candidate was found to have 266 valid signatures, which is 1,289 below the statutory minimum of 1,555 signatures. In light of the results of the records exam, the pattern of fraud claim was not further scrutinized. The hearing officer recommends, and I agree, with adopting the results of the records examination, finding that the candidate had 266 valid signatures, 1,289 below the minimum of 1,555 signatures required by Section 7-10B of the Election Code. The hearing officer and I recommend the objection be sustained and candidate's name should not be placed on the March ballot as a Republican candidate for representative in the 16th.
Mr. Fogarty, anything to add?
Yes, actually, I would ask that you adopt the hearing officer and the general counsel's recommendation. Further, this matter, these petitions should be referred to the state's attorney. They are as rife with fraud as I've seen in many, many years of doing this. The candidate, this is all in the verified objectors petition, the candidate signed as the circulator of all of these petitions, but yet the candidate appears on social media training other circulators to help him with these petitions. These petitions, on the faces of them, contain notes with people's names and dates at the top, indicating, and there's an inference, an easy one, that those are the true circulators, not this gentleman, the candidate. And I wish he was here. He deserves to be here for this. So it is clear that someone else gathered all these signatures for him. He signed as the circulator, but even further, he filed with about 1,600 signatures, 1,400 of which were bad. They were forged. Just the eye test will tell you, because he was so far under, we did not pursue a pattern of fraud, although it was pled. But this is one of the rare cases where it's not close. And if this person portrayed himself as someone who was earnest, maybe didn't understand, that'd be one thing. That's not what this is at all. And so this case, these petitions should be referred to the state's attorney for further investigation. Otherwise, please accept the recommendations. Thank you.
Thank you, Mr. Fogarty. Marnie, do we have the ability to forward to the state's attorney?
Yes, I believe we have a general power to refer to the state's attorney. I would say the state's attorney and attorney general, so that the two of them can decide who has proper jurisdiction to pursue the case.
If someone would like to make a motion in that regard,
Well, I'll make a motion to, for the recommendation of the hearing officer and the general counsel. And then do I need to include the referral to the state's attorney and the attorney general?
Do I have a second?
As well as to sustain the objection and not place the candidate on the ballot. Is that correct?
Yes, ma'am.
You
Do I
know,
have a
wouldn't
second?
it be, excuse me, Madam Chair, but wouldn't
Watson?
it be better to have the referral to the state's attorney or the attorney general separate? Because this is clearly below the minimum with respect to signatures. So is it possible to separate the motions?
As long as the movement is willing to withdraw the motion, I don't see why not.
Yes, of course.
All right, we'll start again. Do I have a motion to accept the recommendations of the general counsel
The general counsel and the hearing officer.
and the hearing
So-
officer? It's been moved and seconded. Amy, roll call?
Ms. Bella Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion passes.
And do we have a further motion?
I make a motion to refer, per Marnie's suggestion, to refer this to both the state's attorney and the attorney general and let them see who has jurisdiction.
Second.
It has been moved and seconded. Amy, roll call, please?
Ms. Bella Croft,
No.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
No.
Vice Chair Turbin.
Yeah.
Chair Donahue.
Yes.
Motion passes.
Thank you.
All right, Marnie.
Okay, our next case is another Mr. Fogarty case, so he doesn't need to sit down quite yet. It's Leitner and Carroll versus Holt, 25 SOEB GP 541. Objectors Leitner and Carroll, represented by Attorney John Fogarty, objected to the nomination papers of candidate Holt, who is present in Chicago and who seeks the Republican nomination for the office of Senator in the 33rd Legislative District. This is a records exam case. Objectors objected to 225 of the 1,047 lines filed by candidate. During the conduct of the exam, 167 line objections were sustained, resulting in 880 valid signatures, which is 120 below the statutory minimum of 1,000 per section 8-8 of the election code. The hearing officer recommends, and I agree with, adopting the results of the records examination and finding that candidate had 80 valid signatures, 120 below the minimum of 1,000 signatures. The hearing officer and I recommend the objection be sustained and the candidate's name should not be placed on the March 2026 general primary ballot as a Republican candidate for senator in the 33rd Legislative District. Before we discuss this, I wanted to note there's another case against Mr. Holt. Is that correct?
There was one.
Okay, just checking. Okay, excellent. I will turn the floor over to the parties.
John Fogarty for the objectors.
Cody Holt, candidate, HRLT, Tom.
Marnie or Mr. Holt, would you like to speak first?
Normally the objectors.
Objector.
If that's
Pardon
okay.
me, Marnie.
No problem.
John.
Of course, we ask that the recommendations of the hearing officer and general counsel be accepted, and Mr. Holt not appear on the ballot.
Mr. Holt.
Candidate would like to make a motion to dismiss.
Afraid the candidate can't do that.
Withdrawn. No, I was just reading John Fogarty. That's all. That's all right. I'm just kind of messing around with it.
All right, do I have a motion?
A motion to accept the hearing officer and general counsel to sustain the objection and not include the candidate's name on the ballot.
Do we have a second? It's been moved and seconded. Amy, roll call, please.
Ms. Bella Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion passes.
Thank you both.
Oh,
Marnie, next.
Next case, agenda item 2R, Christ and Stevens versus Tejeda, 25 SOEB GP 546. We have Mr. Fogarty on behalf of the candidate and Carrie Abbasi, ABB ASI, on behalf of the candidate.
Mhm.
This is a records exam case where objectors Christ and Stevens filed an objection to the nomination papers of candidate Tejeda, a Democratic candidate for representative in the General Assembly for the 105th Representative District. The objector objected to 100 lines within Ms. Tejeda's 534 filed signatures. Following the conduct of a records exam, where 71 of the 100-line objections were sustained, candidate was found to have 463 valid signatures, which is 37 fewer than the statutory minimum of 500 per section 8-8 of the election code. Objector also alleged that candidate did not include a receipt of filing her statement of economic interests. Candidate filed a motion to strike the paragraphs of objector's objector's petition relating to the receipt, arguing that while she did not file the receipt with her nomination papers, she did in fact file it within the time period allowed under section 7-12. The hearing officer recommends, and I agree, the record exam results are dispositive of this matter. As such, the recommendations are that the objection should be sustained, that the motion to strike should be denied as moot, and that the candidate's name should not be certified on the March general primary ballot as a Republican Party candidate for the office of representative for the 105th Representative District.
Thank you, Marnie. Mr. Fogarty?
For the objectors, we agree with the recommendations of the hearing officer and the general counsel.
Thank you, John. Mr. Abbasi?
No argument from the candidate.
Do I have a motion?
Make a motion to accept the recommendation of the general counsel and sustain the objection, and the candidate will not appear on the ballot for the
Do I have
17th, 2026 primary.
a second? Second. It's been moved and seconded. Roll call, Amy.
Ms. Bella Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes. All
Motion
right,
passes.
next up, Marnie.
Thank you. Agenda item 2S, Slattery and Roach versus Badgick, 25 SOEB GP 551. We do not have the candidate present in Chicago or in Springfield. She was already voted off the ballot in case 25 SOEB GP 524 earlier this morning. Are objectors Slattery or Roche present in Springfield?
No, ma'am.
In that case, there are two options. The first is to dismiss for want of prosecution. The other is for me to read my recommendation on the merits. But know that even if there is a dismissal for want of prosecution, Ms. Badgick has already been voted off the ballot.
Make a motion to dismiss for want of prosecution.
Second.
It's been moved and seconded. Amy, roll call?
Ms. Bella Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yeah.
Chair Donahue.
Yes.
Motion passes.
All right, Marnie,
And with that, may I ask for a few-minute break?
you may.
Thank
It's
you.
either now or between the two.
How long of a break are we taking?
5 minutes.
Thank
I'm
you.
at think we're ready. Marnie, you're back.
They're still.
But give me signals, all right. Yeah, they did. They just like had no time to campaign.
In like
And it was a Hispanic district anyway. Yeah, yeah.
All right, are we ready to reconvene? Marnie, are you ready for 2S, I believe?
Oh, we just did.
I believe I just did 2F,
T.
but we're ready for 2T.
2T, all right. We didn't check
That is
that off.
Anderson, thank you. That is Anderson versus Tillman and Mosley, 25 SOEB GP 554. The objector is represented by attorney Kevin Morphew, who I understand is in Springfield.
He is.
And Tillman is here.
And candidate Tillman is here. She is pro se, and candidate Mosley did not appear. I'm going to read my recommendation. Then Mr. Morphew will have an opportunity, 3 minutes to address the board. And then candidate Tillman, you'll have 3 minutes to address the board.
Okay, thank you.
All right, Marnie, go ahead.
So candidate Tillman and Mosley seek the offices of governor and lieutenant governor. There are 3 bases of the objection in this matter. First, the pagination of candidates' nomination petitions, the validity of individual signatures filed, and notarial deficiency on the circulator affidavits. As to the signature challenges, objector objected to 3,767 signature lines of candidates' 7,253 filed signatures. Following the conduct of a records exam, where 2,949 of the 3,767 line objections were sustained, candidate was found to have 4,304 valid signatures, which is 696 fewer than the statutory minimum of 5,000 signatures per section 7-10A of the election code. Candidate did not file a standing objection in this case. After the records exam had commenced, candidate Tillman requested an extension of the conduct of the record exam and requested to stay the case and grant other miscellaneous relief. Here, the hearing officer recommends denying candidate Tillman's request for extensions of time, as candidate Tillman received ample notice of conduct of the records examination. Extension requests were not made until after the exam had already commenced, and the initial request was improperly filed via email without good cause shown under Rule of Procedure 6. Here, the hearing officer recommends, and I agree, that the record exam is dispositive of this matter. Objector's pagination and notarial objections have been rendered moot by the deficient signatures. On this basis, the hearing officer recommends, and I concur, that the objection be sustained and candidate Tillman and Mosley's names should not be certified on the March general primary ballot as Democratic Party candidates for the offices of governor and lieutenant governor.
Thank you, Marnie. Mr. Morphew?
Thank you very much. We ask that the hearing officer's recommendation and general counsel's concurrence be accepted by the board.
Ms. Tillman?
Aye. And ma'am, if you could stand up as close as you can to that green light on the ceiling.
Look up.
That way you can that's the microphone.
Okay,
You have 3 minutes, Ms. Tillman.
okay. Number one, I could not file anything because I was locked out of the portal. I have here from the legal department of the State Board of Elections showing that I did not have access to the portal to file anything. I have that. I was attacked at the State Board hearing by Mr. Morphew, so I was injured. I have hospital records. That's the reason why I could not show up in Springfield to challenge for the record exam. I asked for an extension ahead of time, which they denied. I have the police report and hospital records for me being harmed by Attorney Morphew. I also have a recording of the incident. When I seen what was happening, I started recording the incident. And that's why I could not show up for the record exam. Otherwise, I could have objected to it. But I was not able to file anything. And here, would you all like to see that this is from your legal department?
No additional evidence can be offered at this time.
Oh, well, I had already filed it. I emailed it to them, but the portal I did not have access to. And your legal department sent the email to them, to Mr. Morphew, to the hearing officer, and all as well. I will be asking that you grant their motion that Patricia Tillman and Joseph Mosley name does not appear. I would ask that the name Patricia L. Tillman and Joseph L. Mosley appears on the ballot, which is on my nomination papers, which is on my voter's registration card, and which is on my state ID, Patricia L. Tillman. And on Joseph Mosley's, Joseph L. Mosley, on his nomination papers, on his state ID, and on his voter's registration. So we will be asking that you certify the names of Joseph L. Mosley and Patricia L. Tillman.
Thank you very much, Ms. Tillman. Is there discussion?
Yeah, I have a couple of questions for the candidate.
Member Watson?
You say that you sent something to the Board of Elections by email?
Yes, ma'am. They all got it. And then the legal.
Hold on just 1 second. Do we have any documents that have been received by the Board of Elections from Ms. Tillman by email?
So there have been documents received both by email and by the portal on the day of the records examination.
What are the documents that we've received?
So at 9:29 a.m., there was an unsigned affidavit requesting an extension of the records exam after the records exam had begun. And then later that day at 1:10 p.m. approximately, there was a motion to extend the records exam that was filed into the portal.
And did either of them indicate that she had been the victim of an attack, that she had made police reports?
Yes, they did. Yes, they did.
And that she was in the hospital also?
Off the top of my head, I cannot recall, but it is in your objection packet, all of her filings.
No, I don't have any of those filings in my packet.
Okay.
I just want to indicate that for the record.
Okay, if you could give me a moment, please.
And I also filed ahead of those deadlines that they're saying. I emailed to everybody that I could. I asked that I could proceed during.
Just hold on just 1 minute. Would you just hold on?
Yes.
Thank you.
So flipping to page 694 of the packet, that is the summary sheet. Next is the hearing officer's recommendations. Then if you turn to page 704, that is a motion to disqualify that was filed by the candidate. On page 707 is the unsigned affidavit. Oh, excuse me. I apologize. This one was a signed affidavit by Ms. Tillman. On page 714 is the motion for continuance for record exam / extension. On page 717 is the unsigned affidavit that was submitted. And on page 719 is the initial case management order, one of the many forms of notice that was provided.
So notwithstanding all of these documents being in the Board of Elections hands, who was the hearing officer on this case?
Well, first, the hearing officer was David Herman. At some point, Ms. Tillman moved to disqualify him and asked for a new hearing officer. That motion was granted by me, and Michael Texan was assigned as the new hearing officer.
If I may say, when I asked for a new hearing officer, I also asked for an extension and a continuance for the record exam that was taking place on the 24th. She granted the new hearing officer, but denied the extension, and it denied the extension for me to appear to the record exam.
And that's not accurate.
I had hospital records. I was on, they gave me Norco. Norco is a drug where I couldn't even think right on those drugs. So there's no way I could appear in Springfield.
I would just note for the record that the general counsel only has jurisdiction to rule on motions for change of hearing officers. I do not have jurisdiction to grant objections or to grant extensions of time. So that would have been incumbent upon the hearing officer.
So the hearing officer received all of these things timely? Is that what you're saying, Madam General Counsel?
No, the extension of time was received via the portal approximately over 4 hours after the records exam had commenced. I don't know exactly what time the records exam concluded that day.
That is absolutely not true.
Well, you understand, Patricia L. Tillman, that you were below the minimum. You understand that?
Ma'am, I was not below.
This would be yes or no. Do you understand that you were below the minimum on the signatures that you submitted?
No.
Okay.
You have anything more, Madam Member Watson?
No.
Do I have a motion?
Have we heard from Mr. Morphew?
Yes, he supported the hearing officer's recommendation.
Okay, thank you.
And I would, thank you. Thank you. I would suggest adopting the hearing officer's recommendation to deny the outstanding request for extension of time by candidate Tillman, to accept the results of the records examination as stated by the hearing officer, and find that the objection be sustained, and candidate Tillman and Mosley's names should not be certified on the March general primary ballot.
Ma'am, may I speak? I have from.
Miss Tillman, we're
stating that I could not.
Miss Tillman, we have a motion. It's been moved and seconded. Amy, roll call, please.
And everything was timely filed. They ignored.
Mr. Tillman, you do not have the floor. Amy, roll call, please.
Ms. Bellicroft,
Abstain?
Ms. Gray,
Yes.
Ms. Genovese?
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Abstain?
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes,
Motion passes.
thank you.
And parties be able to-
Marnie?
Yes, parties will be able to pick up their orders from Sean Sarku in the back of the room in a few moments once he has finalized that order. The next case, agenda item 2U, Lipinski versus Dombrowski, 22 SOEB GP 555. We have Attorney Abbasi, ABB ASI, here on behalf of the objectors. The candidate did not ever appear in this case. So this is an insufficient signatures case. Objector Lipinski alleges candidate filed an insufficient number of signatures that were required by section 8-8. Candidate is a Republican Party candidate for the office of representative in the General Assembly for the 56th Representative District. United States Postal Records show candidate was served on November 22nd, but candidate did not appear or participate in this proceeding. Section 8-8 requires a minimum of 500 signatures for this office. A staff signature count shows the candidate filed 490 signatures, which is 10 fewer than statutorily required. Objector moved for summary judgment in reliance on the strict construction required for signature thresholds. The hearing officer recommends, and I agree, that objector's motion for summary judgment should be granted. The objection should sustained, and candidate Dombrowski's name should not be certified to the March general primary ballot as a Republican Party candidate for the office of representative in the General Assembly for the 56th representative district. And Mr. Abbasi is present.
And objector agrees with the hearing officer of the general counsel.
Thank you, Mr. Abbasi. Do we have a discussion? If not, do I have a recommendation, a motion?
Motion to accept the recommendation of the hearing officer and the general counsel.
A second?
Second.
Been moved and seconded. Amy, roll call, please.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yes.
Chair Donahue.
Yes. Marnie?
Next case, 2V, Abbasi versus Shepherd, 25 SOEB GP 556. The objector is self-representative attorney Mr. Abbasi. The candidate Shepherd is represented by Ms. Kolodakis, Kolidakes, but she is not present in Chicago. Is someone on behalf of candidate present in Springfield?
No, ma'am.
Thank you. So the objector objects to candidate Shepherd's nomination papers on 4 bases. First, candidate's petition sheets list a different mailing address from his resident address indicated on his statement of candidacy. Second, the petition sheets are not uniform. Third, the petition sheets indicate an inaccurate district, which amounts to for a false swearing. Candidate filed a motion to strike objector's petition, arguing section 7-10's requirement that petition sheets contain candidate's residence address can be satisfied through substantial compliance. Candidate states that he substantially complied with the provisions of section 7-10 because no voter confusion resulted from his use of a PO box as a mailing address on his petition sheets. In objector's response to candidate's motion to strike, objector withdrew all of the bases of his objection except the allegation that candidate's use of the mailing address PO box invalidates candidate's nomination papers under section 7-10. Here, the hearing officer relies on Lewis versus Dunn, LEWIS versus DUNNE. The citation appears on page 746 of your packet. In Lewis, the Illinois Supreme Court directs us to look to whether the nomination papers create a basis for voter confusion. When answering that question, a subsequent case from the First Appellate Court, Neal, NEAL versus Cook County Electoral Board, also cited on page 746 of your packet, requires looking to the whole of the nomination papers to determine whether there is a basis for voter confusion. Here, the hearing officer recommends finding, and I concur, that the candidate's use of one residence address on his statement of candidacy and a PO box mailing address on his petition sheets creates a basis for voter confusion inconsistent with the requirements of section 7-10 that his nomination papers cannot overcome. The hearing officer therefore recommends, and I again concur, denying candidate's motion to strike objector's petition, sustaining the objection, and not certifying candidate Shepherd to the March 2026 general primary ballot as a candidate for United States Senator for the state of Illinois.
Is there discussion?
Mr. Abbasi is here.
Objector agrees with the hearing officer and the general counsel.
The beginning. Do I have a motion or is there discussion? A motion?
Motion to accept the recommendation of the hearing officer and general counsel.
Okay. It's been moved and seconded. Amy, roll call.
Ms. Bellercroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes. Thank you,
Motion passed.
Mr. Rabasi. I apologize from the last one to this one, and
Oh,
you
no,
both, you said the both things, so I apologize if no disrespect there, sir.
oh, no, thank you.
Next, Marnie.
Next, agenda item 2W, Jones and Garza versus Williams, 25 SOEB GP 558. We have attorney Ed Mullen, Mullen, here on behalf of the objectors. And although the candidate participated in these hearings pro se, he is not here in Chicago. His candidate Williams is killed.
No. He is not present in Springfield.
Okay, I will go ahead and read my recommendation and then Mr. Mullen can have the floor. This is an insufficient signatures case. Objectors are represented by Attorney Mullen, the candidate who seeks the office of U.S. Senator for Illinois. As an initial matter, he appeared pro se. As an initial matter, candidate filed a motion to dismiss, arguing that under section 10-10 of the election code, the board lacks subject matter jurisdiction because objectors failed to appear at the November 18th call of the cases. Objectors' response argued objectors did appear through counsel, Mr. Mullen, at the call of the cases, but missed the initial case management conference due to a miscommunication, which is not a reasonable basis to default objectors. The hearing officer recommends, and I concur, denying candidate's motion to dismiss because objectors appeared through counsel at the call of the cases as provided in our rules procedure, and candidate was not prejudiced by objectors' counsel not attending the initial case management conference. A staff count was conducted and shows the candidate's nomination papers contain 1,576 signatures, although section 7-10A of the election code requires 5,000 signatures. The hearing officer makes two alternative recommendations, and here I recommend adopting the second alternative. The first alternative, the hearing officer recommends, quote, after a cursory review of the objection petition, unquote, that the board on its own motion and under Rule 4B dismiss the petition as it fails to sufficiently state the objector's interest pursuant to section 10-8 of the election code, thereby overruling the objection. In the alternative, the hearing officer recommends, and I agree, with adopting the staff count and finding candidate has filed 1,576 signatures, an insufficient number for the office sought. I think the second option is the more streamlined objection, rules on the merits, and would be simpler for a court to evaluate on judicial review if necessary. So here I recommend adopting the hearing officer's alternative recommendation to sustain the objection based upon candidate's submission of insufficient signatures. As such, it's the recommendation of the general counsel to not certify the name of the candidate as a Democratic primary candidate for the office of United States Senator for Illinois on the 2026 general primary ballot.
Thank you, Marnie. Mr. Mullen?
I have nothing to add other than we concur with the recommendation of the general counsel.
Thank you. Do we have a motion or discussion?
I would just ask that if you choose to accept the recommendation of the general counsel, a more appropriate motion would be to accept the, you could simply say to accept the recommendation of the general counsel as we are adopting only one of, well, the board may choose to adopt the second alternative ruling on this case based on the signatures rather than based on the content of the objection petition. So a recommendation to accept the recommendation of the general counsel would work.
Do I have a motion to that
So
effect?
moved.
Second. It's been moved and seconded. Amy, roll call?
Ms. Ballard-Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right. Marnie?
Agenda item 2X, we have another case against candidate Williams. Same as 558, only this is by objector, Mr. Abbasi, so he is here. This is another insufficient signature objection to candidate Williams' petitions. So in this matter, candidate Williams filed a motion to dismiss the objection petition for lack of subject matter jurisdiction for the board's alleged failure to comply with section 10-10.1 of the election code. And so arguing, the candidate cites to Quinn versus Board of Election Commissioners and alleges that lack of proper service strips the board of subject matter jurisdiction. The objector responded to this motion by noting candidates' statutory and case citations refer to law governing service for a petition for judicial review of an electoral board decision, not service of a notice that an objection petition has been filed. The candidate also claimed he did not file a waiver of service in this matter. Now, the objector filed a motion for summary judgment, arguing that nomination petition signature requirements are mandatory, and candidate has failed to collect and file the requisite number of signatures required by the election code for the office he seeks. The hearing officer recommends, and I concur to deny candidate's motion to dismiss, as board records show that candidate executed a waiver of service by registered mail on November 3rd, 2025, and was emailed notification of the objection and call of the cases on November 11th, 2025, and a copy of that waiver service appears in your packet. The hearing officer also recommends, and I also concur, to rely on the staff count conducted, finding the candidate filed 1,576 signatures, which is 3,424 fewer than the 5,000 signatures required for the office sought. Therefore, the recommendation is for to grant objector's motion for summary judgment. In granting the motion for summary judgment, the hearing officer and I recommend finding the candidate has filed insufficient signatures under section 7-10A to sustain the objection, to deny the motion to dismiss, and to not certify candidate Williams' name to the March 2026 general primary ballot as a Democratic candidate for the office of United States Senator for Illinois.
Thank you, Marty. Mr. Abbasi?
The objector agrees with the hearing officer and general counsel.
Thank you, sir. Do I have a motion?
What would be the motion again?
If we wanted to use a more complete motion, it would be to accept the recommendations of the hearing officer and general counsel, to deny the candidate's motion, and to grant the objector's motion, and to sustain the objection that the candidate not be certified on the ballot. However, simply accepting the recommendation of the hearing officer and general counsel would also be sufficient.
So moved.
Second.
Been moved and seconded. Amy, roll call?
Ms. Bellicroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Marnie?
Okay, this is a second case against Jump Shepherd. The first was case number 556. This is case 560. We have an appearance by the objectors for Ed Mullen and an appearance on behalf of Mr. Shepherd by Kyra Kolodakis, KHYRA space KOLIDAKIS. However, Ms. Kolodakis is not present in Chicago, and we previously confirmed she is not present in Springfield. This is case 25 SOEB GP 560. Here, the objectors object to candidate Shepherd's nomination papers, alleging that his use of a PO box mailing address on his petition sheets is a violation of section 7-10 of the election code. Counsel for candidate filed a motion to strike objector's petition based on the principle of liberally construing the election code in favor of ballot access and substantial compliance. Objector's response cites to and relies on Ryan versus Landick, RYAN versus LANDEK, which is cited on page 815 of your packet, where the first appellate court recognized that the purpose of the residence address requirement on petition sheets is to prevent a candidate from running in an election when he is not entitled to do so. So the objectors argue that the presence of a PO box on the petition sheets does not inform voters that the candidate resides in Illinois, contrary to the purpose of the requirement's inclusion on the petition sheets. Absent that information, candidate cannot be deemed to have substantially complied with section 7-10. The hearing officer recommends here, as she did in case 556, and I once again concur, finding that candidates' nomination papers do contain a basis for voter confusion by their inclusion of a different residence and PO box mailing address, and therefore cannot be met through either strict or substantial compliance, and do not comply with the provisions of section 7-10. As such, the hearing officer recommends, and I concur, denying candidates' motion to strike objector's petition, sustaining objector's petition, and not certifying candidate to the 2026 general primary ballot.
Mr. Mullen.
I have nothing to add, given that the board voted on this earlier today. Thank you.
Thank you, sir. Do I have a motion?
I have a motion to follow the hearing officer and the general counsel's recommendation in denying the candidate's motion to strike objector's petition, sustaining objector's objection petition, and not certifying the candidate to the 2026 general primary ballot.
Second.
Been moved and seconded. Amy?
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yeah.
Ms. Genovese. I'm sorry, what was that? Is that a yes or? I'm sorry,
Nope, I was speaking over. And
Okay.
I apologize.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Marnie?
So our last two cases are 562 and 563. They are both seeking the removal of Adam Delgado as a candidate for United States Senator. Ed Mullen is present on 562. Perry Abbasi is present on 563. Would you mind if I take these cases together as they are virtually identical? Thank you. So candidate Delgado did not appear or participate in these proceedings. He waived service by registered mail when filing his nomination petitions. SBE staff emailed notice of the objection to him on November 11th, consistent with candidate's waiver of service. This is an insufficient signatures objection, with all of the objectors alleging that candidate's nomination petitions do not contain the 5,000 signature statutory minimum necessary under section 7-10A. A staff signature count showed that candidate filed 1,719 signatures with his nomination papers. In case 563, Mr. Abbasi also filed a motion for summary judgment, arguing that signature requirements are a mandatory provision of the election code and that the objection should be sustained due to candidates' insufficient signatures. The hearing officer recommends in both cases, and I concur with relying on the staff count, finding 1,719 valid signatures, which is 3,281 below the statutory minimum of 5,000 signatures required by section 7-10A of the election code. As such, and in reliance on Jackson Hicks, Jackson /HICKS versus East St. Louis Board of Election Commissioners, 2015, Bill App 5th, 150028. The hearing officer recommends sustaining the objection and not certifying the candidate's name to the 2026 general primary ballot for United States Senator from Illinois.
Thank you. I assume Mr. Mullen and Mr. Abbasi that we're okay with the recommendation?
Yes.
Yeah, yes, Madam Chair.
Do I have that recommendation?
Marty, just to clarify, you want to take 562 and 563 as one vote?
I think that's fine, considering it's the same candidate and the exact same evidence and the same results.
Okay, then I will make a motion to accept the recommendation of the hearing officer to sustain the objection and not certify the candidate's name to the ballot.
Thank you. Do I have a second? It's been moved and seconded. Amy?
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Hallelujah. All right, Marnie.
Um,
Thank you, guys.
Thank you. Moving forward, to agenda item 3, we have a number 16 of withdrawn cases, either objectors or candidates have withdrawn. Those are agenda items 3A through 3P. I'd like a motion to dismiss all of these cases due to the withdrawal of either the candidate or the objector.
Do I have a motion? It's been moved. Do I have a second?
Second.
Amy, roll call.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yes.
Chair Donahue.
Yes.
Motion passes.
Anything else from you, Marnie?
Not from me, thank you.
All right. Do we have other business? If not, do we have comment from the general public? All right, I will ask for a motion to recess the State Officers Electoral Board until Wednesday, January 7th, 2026, at 10 a.m. or until the call of the chair, whichever occurs first.
So moved.
Second.
Roll call, Amy?
Ms. Bellarcroft,
Yes.
Ms. Craig.
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin.
Yes.
Chair Donahue.
Yes.
Motion passes.
Am I right on that time, Bernadette? 10? The 7th?
Yes,
Okay.
I think we agreed 10 o'clock for the special meeting rather than.
Okay. 9. All right, so it's Wednesday, January 7th at 10 a.m. All right. Now, since we had a break, can we go ahead?
So actually, some of the campaign disclosure parties came in this morning and we told them to come back in about 2 hours. And my voice is also could use a break. So if you don't terribly mind, another break would be much appreciated. That way we can also get the board orders out to the objectors and candidates and wrap up all of the SOEB matters before we proceed into campaign disclosure.
That's fine, Marnie. Then why don't we return at 11:15? That'd be fine?
Wonderful. Thank you so much.
All right.
Oh.
Yeah. I did. I'm a little,
Yeah, we're just getting ready.
3 more minutes.
We're just getting ready.
Actually, 4.
You know me. Are you ready in Chicago?
I know. Yes, we are.
All right. Miss
Thank you.
Member Watson, are you there? Not there. Member Watson? There she is. There she is. Okay. I will reconvene the State Board of Elections and we will hold a roll call. Amy?
Ms. Bellarcroft,
Yeah.
Ms. Craig,
Yes.
Ms. Genovese, here, Ms. McCory,
Here.
Mr. Brett,
Here.
Ms. Watson,
Here.
Chair Turbin,
Here.
Chair Dunn.
Here. All right. Report of the General Counsel. Settlement offers. Marnie?
Good morning, everybody. I know you've missed my voice. We have a settlement offer here first on the agenda. It's agenda item 3A1 SBE versus Friends of Jessica Frank, 25 MF 146. Is Ms. Frank's present in Springfield?
She most certainly is.
Wonderful. Well, Ms. Franks, I will read my recommendation and then you will have 3 minutes to address the board. Today, we will be limiting all speakers to 3 minutes. This committee made an offer in November. It was denied because the committee never filed any quarterly reports. Please note this candidate is facing potential ballot forfeiture if this matter is not resolved by January 8th. The candidate has since opened a successor committee, so even if there was no ballot forfeiture issue, these fines would not expire. After the November meeting, the candidate filed 3 quarterly reports. for the third quarter and fourth quarter of 2023, as well as the first quarter of 2024, along with a final report for the second quarter of 2024. Those reports show that combined, the committee did exceed the $5,000 threshold. The reports show $4,354.45 in itemized receipts in the first quarter of 2024, but all other entries in the quarterly reports are not itemized as required by Section 9-11 of the Election Code. Our Director of Campaign Disclosure, Tom Newman, reported to me that the candidate said records are not available to itemize the remaining contributions and expenditures on her other reports. I will remind the board, however, that Section 9-7 requires a treasurer to keep these records for a period of 2 years. Here, the committee is offering $300, which is 9.23% of the outstanding fines of $3,250, and fines for failure to file the March, June, and September 2024 and March 2025 quarterly reports. The offer form mistakenly lists the amount of fines owed as $3,000 rather than $3,250. So a corrected offer form is included on page 4 of your packet, showing the correct amount of the fines. The committee here meets the balance and receipt ratios, and although the offer is below the 50% standard, the committee is low dollar and has also filed a final report and is closed. If the board wants to ensure compliance with Article 9, it could order the committee to properly itemize its quarterly reports. Alternatively, or in addition, the board could accept the $300 offer, which is otherwise compliant with settlement guidelines.
Thank you, Marnie. Do you plan to run further?
It's just for precinct committee.
Okay, so it's,
yes,
you still have to do it.
yes.
All right, we have Ms. Franks here, so if you'd like to address the board.
No, I appreciate giving the opportunity to do this, and I'm sorry that I didn't. I mean, ignorance of this it's all on me. So I know I was upset and trying to blame it on somebody else, but really, ultimately, it's my fault. So I'm sorry that I don't. Yes, sir.
No, I'm gonna.
No, we agree with you. And
Okay.
We
Yes.
understand.
Okay, I'm sorry.
But ignorance
Yes.
isn't there.
No.
So, do I have a motion?
I'd like to make a motion, we accept the $300 and get this case over with, and wish you the best if that happens.
Second. Yep. We have a motion and a second. Amy.
Ms. Bellercraft?
Yes.
Right?
Yes.
Ms. Genovese? Yes. Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion.
Thank you.
And you run for bigger and better things.
Happy holidays.
It's an intimidating game. That's for
Now you gotta go for it. Thank
Right.
you.
Thank you all.
Thank you. All right. Next up, Marnie.
Moving into appeals of campaign disclosure fines, in which the recommendation is to deny the appeal. Is anyone present on 3A2 or 3A3? If not, we'll skip over those for now.
Yes, no, we have, Becky Bakers?
Rakers.
Sorry. We have Miss Rakers is here for 2A2.
Excellent.
Three.
So A2 SBE versus Illinois Association of Mutual Insurance Companies, Farm Mutual PAC, 25 MQ9. The committee is appealing a $25 civil penalty assessment for the 1-day late filing of the March 2025 quarterly report. The committee has a previously stayed penalty of $250 for late filing of the June 2024 quarterly report. The committee's treasurer was unable to timely file the quarterly report due to a personal family emergency and has since established an emergency filing plan for the committee. I agree with the hearing officer that the appeal should be denied for lack of a statutory basis. If this recommendation is accepted, the stay will be lifted on the previous penalty and $275 owed.
Ms. Rakers.
Yes.
And
Thank you.
If she could spell,
Marnie?
I'm sorry,
Yeah.
if Ms. Rakers could spell her name, that would be helpful.
Yes, it's like you rake your yard, so RAKERS. Gets confused all the time, by the way. Go ahead. Okay, first of all, thank you for allowing me to come forward. It's a minimal fine, but it's an important thing for us. We are a company of integrity, and I'm highly embarrassed representing everybody that I would put them in this situation. So that's why I'm fighting. But I did receive the report from the hearing officer identifying that there is no statutory relief for emergencies. And I understand that and I respect that, but I do ask if the board has any opportunity to exercise any available administrative discretion to waive these penalties. I believe that the intent of the regulation is to promote timely compliance, but I don't believe that it is to penalize anyone that becomes faced with an unavoidable emergency. We have implemented very, very strong internal procedures that will allow multiple people to step in when the one-person office is closed. So we had made arrangements in the, what would it be, second quarter of 24. My daughter had a brain aneurysm, and while I was on the phone with someone trying to help them, I could not mentally think. I just couldn't come up with passwords or remember how to get things. And so, you know, we were stayed on that one, and I was so grateful that I didn't have to do that. And of course, no expectations of ever filing late again. I didn't pursue an appeal on that. And then I lost a very close family member after being intentionally out of the office for 5 straight days. I had 3 days for a family leave, not again mentally recognizing that I had not filed, because I normally would have by then had I not been out for work the week before. So there was 2 definitely situations that won't happen and shouldn't happen. Not that deaths can't happen and if people can't get put back in the emergency rooms or the ICU units, but we do have new procedures in place. And I do hope that you have some administrative abilities to look at that and waive these fines.
I appreciate that, Ms. Rickers, truly. We all do. And we've had many situations very similar, but we don't have the ability to do that. And so do I have a motion?
I make a motion to accept the recommendation of the general counsel and the hearing officer.
A second? It has been moved and seconded. Roll call, Amy.
Ms. Bellercraft?
Yes.
Ms. Craig?
Yes.
Ms. Genovese? Ms. McCory?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you for allowing me the time.
You are more than welcome. All right, Marnie.
Thank you. Confirming no one is here on 3A3. I recommend, there's only one denial for which we don't have an appearance. So I recommend accepting the recommendation of the hearing officer and denying the appeal.
On 2A3?
On yes, on A3.
So moved.
Do I have a motion?
So moved.
Second. Been moved and seconded. Roll call, Amy?
Ms. Bellercraft?
Yes.
Right?
Yes.
Ms. Genovese? Yes. Ms. McCory?
Yes.
Brett?
Yes.
Watson?
Yes.
Vice Chair Turbin?
Yes.
Chair Donahue?
Yes.
Motion passes.
All right, Marnie.
Next case, 3A4 SBE versus Equal Justice Party, 25 NF4. This is a longer recommendation because there are a number of outstanding motions for the board to rule upon. So I will read my recommendation, and then Mr. Stoller will be able to spell his name and have 3 minutes to argue to the board. So this committee has had a $0 balance for years and is still a paper filer, and the case has a number of complexities. There are motions that need to be ruled upon. There are also constitutional claims raised over which the board lacks jurisdiction. The committee is appealing a $1,500 penalty for failure to file the September 2024 quarterly report. To date, the report still has not been filed. The committee also has unpaid penalties totaling $6,750 for 4 separate late quarterly reports dating between 2016 and 2021 So if this appeal is denied, $8,250 would be owed. The only filing at issue in this appeal is the September 2024 quarterly report, as the committee did not file appeals of the assessments dated 2016 through 2021, and final orders were issued in those cases years ago. As to the September 2024 quarterly report, the committee says that it timely mailed the quarterly report, that no contributions were received during the quarter, so there was no attempt to avoid disclosure compliance, and third, that the fines are unconstitutional. As to the timely mailing argument, the relevant provisions of the board's postal defense are codified in Rule 100.125B through C. Under subsection B, if the envelope containing the quarterly report is not received by the board, the report will either be deemed to have not been received. If the committee is assessed a civil penalty for failing to file the report, and as part of the committee's appeal of the civil penalty assessment is alleged by the treasurer, chair, or candidate on a signed and notarized affidavit verifying that the report was mailed no later than 3 days prior to the filing deadline, and this is the first time the committee has made this claim, then the presumptive date of receipt will be rebutted by the testimony contained in the affidavit, and the report will be deemed to have been timely received. However, if the committee has already used the 100.125B affidavit, then subsection C applies, which provides that the committee raises the defense in Part B. An appeal affidavit must be accompanied by a certificate issued by the U.S. Postal Service showing the date on which the envelope was deposited with the U.S. Postal Service. The board will not consider this defense as valid in the absence of a USPS certificate. Now here, this committee already used under Rule 100.125B, the postal defense in 2012 in case 11 SQ 142. Therefore, subsection C applies, and in order to use a postal defense an additional time, the committee needed to provide a USPS certificate showing the date on which the envelope was deposited with the USPS, and no such certificate was produced in this appeal. Therefore, I agree with the hearing officer that the committee is not able to use the postal defense here. Respondent also argues it received no contributions during the third quarter of 2024. That defense fails because Section 9-10B requires all committees to file quarterly reports, even if no contributions are received. As to the committee's argument that the fines are unconstitutional, the board lacks jurisdiction to question the constitutionality of Section 9-10, which requires imposing fines for late filing of quarterly reports. A citation in that case to Delgado, DELGADO, versus Board of Election Commissioners of City of Chicago, 224, Ill 2nd, 481 from the year 2017. The board also needs to rule on 4 pending motions, so I will go through each motion one by one.
Okay.
Respondent's motion to dismiss, which starts on page 31 of your packet, argues the board failed to provide requested copies of the evidence underlying the case. I recommend denying the motion to dismiss because first, under Rule 125.425I, the burden in a civil penalty appeal is for the committee to show by a preponderance of the evidence that the assessment notice was in error, not for the board to show that the assessment was warranted. And number 2, the September 2024 quarterly report's absence from the public record is the chief evidence against respondents. Everyone has access to the public record. The second motion is respondent's motion to compel production of documents, a request for suspension of proceedings, and request for ADA accommodation. It argues that respondent has not been provided with a full complaint in this matter, that respondent requires a continuance of the appeal hearing to review any additional documents provided pursuant to this request, and that respondent's chair, Leo Stoller, LEOSTOLLER, requests that all documents be transmitted electronically via email and that additional time be granted to allow for proper review of any additional materials due to his disability. I recommend denying the request to be provided with a full complaint in this matter because under Rule 125.425C, civil penalty assessments are initiated by an assessment notice, not a complaint process like a D4 complaint, and the appropriate rule was followed and document provided in this case. I recommend denying the request for suspension of proceedings as moot because the appeal hearing was in fact completed. And I recommend granting the request for ADA accommodation to receive documents electronically and deny the request of time for additional time as moot, as the hearing did in fact proceed without the hearing officer having ruled on the motion. Third, respondent's motion for substitution of administrative law judge as a matter of right and to stay hearing on page 45 of your packet should be denied as untimely under Rule 125.100, which provides that a change of hearing officers must be requested at least 24 hours prior to the commencement of the hearing. The committee filed its motion via email at 6:42 p.m. on August 25th, the night before the August 26th hearing, which was less than 24 hours prior to the hearing. So I recommend denying that motion as untimely. The request to stay from that motion can be denied as moot because no hearing officer substitution occurred, so no stay was needed for a change of hearing officer. Oh, can you still hear us in Springfield?
And
okay, we're having issues. Oh, we had an issue with one monitor going blank, but it looks like it's back up and running. Fourth, respondent's motion for a more definite statement on page 50 of your packet seeks more details of the alleged violation. I recommend denying this motion as the committee was provided with the assessment notice required by Rule 125.425C, and again, the absence of the September 2024 quarterly report from the public record is the evidence in this case. Now, throughout this proceeding, Mr. Stoller has asked for Americans with Disabilities Act accommodations, though not always specifying what was requested. I'll note for the record that Mr. Stoller has been permitted to participate in all proceedings remotely, and presentation of this case to the board has been postponed for a few months now, as requested by Mr. Stoller due to his health. He was also permitted to appear remotely today as an accommodation. Once the committee has had a chance to address the board and questions have been answered, I can help suggest a motion to encompass all facets of this case, which includes dismissing constitutional claims raised in the appeal for lack of jurisdiction, ruling on the remainder of the appeal, and ruling on 4 motions. And
thank you, Marnie. Appreciate that. We'll get that to the motion when we get there. Mr. Stoller, you're on.
Yes, this is Leo Stoller. Is it my time?
Sorry. You have 3 minutes, sir.
Okay, all the quarterly reports were timely sent in. I don't know how many of you people live in Chicago, but the mail here is atrocious. And the presumption is that once I mailed them, that you received them. And secondly, these motions that were denied, we did not have a complete copy of the complaint. Equal Justice didn't, and therefore we were not able to properly prepare our defense. What I'm attempting to do, because counsel evidently denied all my motions, is before you now to exhaust all of the Equal Justice's administrative remedies, and that I'm putting the board on notice that I attempt to appeal whatever decision you render to the circuit court and allow them to determine the issues here, because I think it's obvious from what I have heard right now is that I'm not going to get a fair and impartial hearing. I didn't get a fair and impartial hearing in front of Mr. Hines. I submitted a transcript of the hearing that took place in front of Mr. Hines, and it was a sham, and he wasn't interested in any of the committee's defenses. And the fact that I'm now before the board and all my motions have been denied, I am putting the board on notice that I intend to immediately file a circuit court appeal of whatever decision you render, because it's my belief it's not going to be a fair and impartial hearing. Decision as such, as the same as Mr. Hines's. And I think it's obvious that none of the members of the committee have read the transcript, which I submitted of the hearing. And if you read that transcript, you would see that it was an absolute sham. And I am confident that a circuit court judge will rule in favor of the Equal Justice Committee, because I don't feel equal justice is getting or will get any equal justice before this particular committee. But I want the record to show that every one of the mailings on all the quarterly reports were timely mailed from Chicago, put into a mailbox and sent to you, or sent to Springfield. And if Springfield didn't receive those or any of those, or whatever they claim they didn't receive, then that's I don't have an obligation, as far as we could see, to carry the mail all the way to Springfield. And more importantly, none of the quarterly reports, no income was accepted or received on any of the quarterly reports. So there is no damages. There was no possible impropriety, because Equal Justice did not accept any or receive any contributions for all of the periods in which we are charged for not filing properly. I do appreciate the opportunity to be before the board. I appreciate the extensions given to me, and I rest my case.
Thank you, Mr. Stoller. We appreciate that and look forward to the future. Do I have a motion?
If I may, very quickly.
Oh, yes, I want Marnie to state the motion, and then we can.
I have a quick correction of the record first. Mr. Stoller, the board has not yet ruled on your motions. I made recommendations on your motions, but the board is free to accept or deny and vote on the motions however they choose here. So the motions are still pending at this moment.
Was there a hearing officer in this case?
Yes, it was Jason Hines, INDS.
Would you spell that to me again, please?
HINDS.
And is there a first name?
Jason, JASON.
Thank you.
Anything further, Member Watson?
No.
Marnie?
So I would suggest a motion to accept the recommendations of the hearing officer and the general counsel to dismiss for lack of jurisdiction the portion of the appeal that raises constitutional claims, to deny the remainder of the appeal, to deny the motion to dismiss, to grant in part and to deny in part the motion to compel production of documents, request for suspension of proceedings, and request for ADA accommodation, as the recommendation is to grant electronic access to records to the appellant, and to deny the remainder of the motion, to deny the motion for substitution of administrative law judge as a matter of right, and to stay hearing as untimely filed under Rule 125.100, and to deny respondent's motion for a more definite statement.
Thank you, Marnie. There's a question from Member Craig.
Mr. Stoller, may I ask you, these delinquent filings go back to 2012. And as you stated, you don't believe the mail service is doing you justice. Did you think of perhaps maybe getting a different way to get these reports to us than just via the mail? And do you have an idea going forward how you're going to do that?
Well, we have not had the with any of the last many quarterly reports. There's been no failure on the committee to have accepted them. We get receipts. But unfortunately, on some of the ones that we are now contesting before the board, we didn't get receipts. And but if you look at Equal Justice's filing record in the last year, or what this is 2025, our filings have been complete. And what we would commit to do to the board is send everyone in the future, even though you have received everyone in 2025, we would send them by Federal Express to Springfield to make sure that you did receive them. It's our intent not to avoid getting our quarterly reports in, but it's also important for the board. Equal Justice is a committee that's been around for, I don't know, 10 or 15 years. And we very rarely we don't accept any contributions. We don't have any funds to cover this alleged fine. If you do level a $6,000 fine against Equal Justice, there is no funds to even possibly cover that. That would be a violation of the Eighth Amendment, an excessive penalty for.
All right.
Thank you. May I ask one more follow-up? If you don't receive any funds, you're not fundraising, you're not accepting contributions, why don't you fine aloud?
Because we're entitled to our First Amendment right to participate in the electoral process, and we're not gonna file out. We've been a committee for what, 10 or 15 years, but the bottom line is we have a right to be a committee. We have a First Amendment right to participate in the process, and we're not going to do that.
All right, thank you, Mr. Stoller. Do I have a motion?
A motion for what the general counsel stated.
Do I have a second?
Second.
Roll call, Amy.
Ms. Bellicroft,
Present.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Verret,
Yes.
Ms. Watson,
Present.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Marnie, next case.
Just briefly, and Mr. Stoller, if you want to take a look at our rules, 125.450 is a rule on settlement of civil penalties. You can reach out to Campaign Disclosure because this might be a good case to reach a low settlement in light of the committee's $0 balance.
I appreciate that, but I'm putting the committee on notice that we'll be filing a lawsuit against the committee, and we are confident that a circuit court judge in Chicago would be somewhat more sympathetic and empathetic to our organization, and would recognize that we should not be subject to such an excessive penalty, and that we made a good faith effort and continue to make a good faith effort to make sure these quarterly reports are in. We don't, our group does not want to be there, not get our reports in. So anyway,
Thank you,
so
Mr.
that
Stoller.
you're on notice,
Yes.
we're gonna file a lawsuit.
Thank you, sir. We've got your notice. All right, next, Marnie.
Next case, 3A5 SBE versus Putting Children First in Thornton Township, District 205. The case number is 25 AM 29. I will read my recommendation and then the committee will have an opportunity to comment. The committee is appealing a total of $8,500 in civil penalty assessments for the 25-day late disclosure of 4 A1s dated April 12, 2025, totaling $12,500 in contributions. These are the committee's 3rd through 6th violations. Attorney Steve Ladazinski appeared on behalf of the committee, and he's here today as well. Ladazinski, Ladauzzinski. The respondent argued that the delay in reporting was due to their treasurer's illness. The committee has since updated its internal procedures to ensure reports are timely filed. Here, I agree with the hearing officer that this appeal should be denied for lack of an adequate defense. The committee also asks that the board waive or reduce the fine under section 9-10G. I see no compelling reason to grant a waiver here, but the committee is welcome to make a settlement offer to seek a fine reduction.
Thank you, Marnie. Mr. Ladowinski?
Yes, on behalf of the committee, the treasurer, Ina Graham, who's a elderly senior, was hospitalized. So the checks came in, were received, and she physically could not do it because she was in the hospital. I know that's not statutory defense, but that is what occurred in this situation.
Do you want to make a settlement offer, sir?
Yes.
How do I need to do this, Marnie? Do I need a motion to accept, or do we need the offer, or what do we do?
Well, if we can either make one motion to deny the appeal and then handle settlement, or alternatively, Mr. Ladowinski could make an offer. We could see if there is something, and then we could do a group motion on the appeal and the settlement offer. So it's up to you.
Would you like to make an offer, sir?
Yes, $2,000.
2,000.
Yes.
Marnie?
So this committee is not low dollar. Its most recent balance reported was $11,734.53. However, I will note that the ratio of fine to balance and ratio of fine to receipts are acceptable within the board's intended range and under Rule 125.450. So my recommendation is to deny the offer because it's not 50%. 50% offer would be $4,250.
Mr. Lewis, would you?
I will count myself at $4,250.
He would accept the 4,250, right? Is that what you said, sir?
Yes, that's correct.
All right. Wonderful. Then do I have a motion?
I the appeal, accept the settlement offer.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft?
Yes.
Ms. Craig?
Yes.
Mr. Nevezi?
Yes.
Ms. McQuarrie?
Yes.
Mr. Brett?
Yes.
Ms. Watson?
Yes.
Vice Chair Turvin?
Yes.
Chair Donahue?
Yes.
Motion passes.
Thank you, Mr. Ladowinski. I wish they were all like that. Next, Marnie.
Agenda item 3A6, SBE versus Friends of Zoe Carter, 24 DQ 143. It appears Ms. Carter is online to address the board, but I will first read my recommendation. Please note that this candidate is facing potential ballot forfeiture. So if this appeal is denied, this closed committee also has a settlement offer to extend. The committee is appealing a $1,500 civil penalty assessment for the 35-day late filing of the December 2024 quarterly report. The committee also has unpaid penalties totaling $1,750 for late filing of the March 2023, March 2024, and June 2024 quarterly reports. So if the appeal is denied, a total of $3,250 will be owed. Please note there's a typo in the hearing officer recommendation. The fine for the late June 2024 quarterly report was $1,000, not $1,050. The committee says it was not aware of the obligation to file a final report to close the committee, and it did have one quarter with activity even after it mostly ceased operations in December of 2023. The committee, however, did not file a final report until March 11th, 2025. Here, section 9-5 does require filing a final report to close a committee, and not knowing the law is not a defense. Therefore, I agree with the hearing officer that the appeal should be denied for lack of an adequate defense. As amended of the hearing officer recommendation to show the correct $1,000 figure for the June 24 quarterly report fine in lieu of the $1,050 stated in the hearing officer recommendation. Now, we have more recently received a settlement offer from the committee, so I'll read my recommendation on that. So here, in the event the appeal is denied, the committee is offering $812.50, which is 25% of the amount owed, to settle $3,250 in fines for late filing of the December 2023, March 2024, June 2024, and December 2024 quarterly reports. The offer is compliant in terms of balance and receipts ratios, and although below the 50% standard, the committee is considered low dollar with a $0 balance. Committee is also closed, which is a factor to be considered in determining the amount of an appropriate settlement. Therefore, I recommend accepting the settlement offer of $812.50.
Ms. Carter, if you have 3 minutes, if you want to address anything, or we can just go ahead with the vote.
Hey, yes, I'll just be really, really quick. So, thank you all for letting me come up here and speak today. I really appreciate it. With the settlement, or sorry, not settlement, with the fine, I understand and I agree that not knowing the law is not a valid defense. It's not. That being said, when I had originally done this committee, when I originally formed this committee, I had put in that I was going to, I had absolutely no idea. It was brand new to me. I was still learning what the law actually was. And so I had not actually raised the $5,000 to even have to start that process, even though I did go ahead, because I was under the assumption that even if I raised $1, I had to put up that committee. I've since learned that and not doing that anymore. But in total, our committee raised about $940. And so being charged a fine of $3,250 and whatnot is four times more than what our committee even raised at that time. So I would really appreciate and I would love to move forward with just declining all the fines, but also knowing that it was a matter of education on my own part, which is why I went ahead and put in that settlement offer to counter that. So that's all I have.
Thank you very much. Marnie, do I have a motion?
The recommendation would be to deny the appeal and accept the settlement offer in the amount of $812.50.
So moved. It's been moved and seconded. Amy, roll call, please.
Ms. Ballarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you, Ms. Carter. All right, Marnie.
For 3A7, we have an informational memorandum on the good committees who've paid their civil penalty assessments. And with that, we can get a motion to go into closed session for the purpose of hearing closed preliminary complaints.
Do I have a yeah, go on.
I'm sorry, complaints following closed preliminary hearing pursuant to Election Code Section 921 and Section 120/2C4 of the Open Meetings Act.
Do I have a motion to move? A second? It's been moved and seconded. Amy, roll call, please.
Ms. Ballarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese, Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.